It is a great pleasure to have here today Professor Stefan Kirste. Professor Kirste is German scholar, well-known German scholar, has published many books, including one that was translated in Portuguese, Teoria do Direito, which is unfortunately sold out. It's in need of a second edition. And Professor Kirsten teaches in Salzburg Law School. It is really a gift for us to have you here for this lecture. Thank you. This is a graduate class, so that's the reason why we don't have many students here. But I hope we can have a lot of interaction. We can talk. I mean, we have already discussed. Feel free to 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 coordinate this class the way you want. Thank you very much indeed for being here with us.
Thank you. Yeah, thank you, Ronaldo, very much for the invitation here. It's an honor, actually the first time I'm at the USP. I've been to many Brazilian universities in the past, but not to the, I think, most important one, and certainly the best one in Brazil. So it is an honor and a privilege, and I hope we all make fun of this session. I'm going to present a couple of theses on the question if a concept of law is possible, and a few remarks on my concept of law. And if you have questions, feel free to interrupt, but I would suggest that we have a discussion, and I would be very happy to hear your remarks. It is, I think, a privilege of scholars not only to present their ideas to different audiences, but also to learn from these audiences and integrate aspects they might have overlooked. And this is my intention for today. So as I said, I'm going to present a theory about the possibility of a concept of law, of a concept of law, and then make a few remarks on my own concept. Now, if you look at the question, is a concept of law possible? Then you have to look at two issues, a substantive issue, we'll discuss this later, and a methodological issue. What are you looking for if you look for a concept of law? Are you going to describe a certain social practice? Or are you going to develop an abstract concept which you then apply on a certain practice, on a social practice? And you will see in the end, I will turn up with the later, which is quite different from American analytical approaches to the concept of law. So let's just jump into it. Julie Dixon, a colleague from Oxford, says, I'm using the nature of law to refer to those essential properties which a given set of phenomena must exhibit in order to be law. In the theories I'm going to present you, she has quite a middle ground. She thinks a concept of law, which is the prerequisite of speaking about the nature of law, is possible. I'm using the nature of law to refer to essential properties. So there are essential properties that a certain social phenomenon must have in order to be called law. In the article I'm drawing this argument from, she also said that jurisprudence is not market research. She criticizes theories that only analyze social practices. It's fair enough for legal sociology to analyze, to make these market researches. But if you want to develop legal philosophy, then you have to make evaluative claims. Rather, they make evaluative judgments about participants' self-understanding. Now that's the next question. How far do we have to take into account self-understandings of citizens pretending to participate in legal practices? But to summarize her point very roughly, very briefly, she is optimistic that there can be a concept of law, and this concept is an evaluative concept and not merely a descriptive concept. In this, she departs from H.L.A. Hart's concept. I'm not pretty sure that you are familiar with his ideas and also with the development of his ideas from his first edition to the second edition of the concept of law. So in the first edition, he was very close to Wittgenstein, if I may say so, some advertisement for science in Austria. Wittgenstein originally came from Vienna and only then moved to Oxford, to England. So Hart now is decidedly skeptical about the concept of law. And he says, questions such as those I have mentioned, what is a state, what is law, what is right, have a great ambiguity. The same form of words may be used to demand a definition, or the cause, or the purpose, or the justification, or the origin of the legal or political institution. And he further elaborates that concept of state, of law, can be talked of in a very different way. So what he does is he starts from the language of the use of the word law and finds that we have overlapping meanings in the sense of family resemblances, but there is no essential, there is no number of essential properties of the law that could be called a concept of law. Oh, you only see my belly. Yeah. that's quite bad. Sorry. Okay, I hope you can see me better now. And as you well know, for the purpose of identifying these family resemblances, yes, this distinction between the participant perspective and the observer perspective, one is bound by the law, one the external perspective observes the law from the outside. So this is quite remarkable. You make an academic distinction and suddenly you have two different perspectives that don't match. How can it be that the observer sees something different than the participant? It is clear that the observer may not be bound by the law, but if you distinguish between the bindingness of law and the concept of law, then it's very strange that the observer perspective and the participant perspective should come to different results with regard to the concept of law. The bindingness is the difference, and the bindingness certainly follows, or legal bindingness certainly follows from the concept of law, but the concept should be the same. This distinction, as you know, has become very famous. Even our dear friend Robert Alexi works with it, although he has a very different approach to the concept of law. It is remarkable, but I'm only mentioning it here, that in the postscript of 1993, he is more optimistic and speaks of essential elements of the concept of law. So there seem to be necessary properties of the law being identifiable that could be called essential elements of the concept of law. And this essence of the essential would then be a nature of law. I think Julie Dixon builds on this later concept. Now, we are just observing the contemporary language, the contemporary theories, analyzing the language, the use of the term law in ordinary language. Joseph Raz, also well known, claimed that the concept of law itself is a product of a specific culture, a concept which was not available to the members of earlier cultures, which in fact lived under a legal system. Okay, so he speaks of a cultural dependence of the concept of law. Or contemporary concepts would not have been available to earlier members of earlier cultures. This is quite evident, but it leads to a relativity of the concept of law. We now have different concepts of law than earlier cultures. And this ultimately leads him to a relativism that is skeptical about the possibility of knowing or constructing a nature of law. However, he makes such an attempt, speaking of law as legitimate authority, and speaks of our concept of law. Now, he justifies, of course, why legitimate authorities are the essential properties or the necessary properties of law, but it is unclear what he means when he speaks of our concept of law. What is us in this sense? Is it the Western world? Is it England, Israel? Is it a universal us as human beings? And is authority really a worldwide agreed concept, property of law? Is authority really necessary? And authority in what sense? Are there authorities that don't produce law? Does any authority produce law? Or do we have to specify the term authority? I feel that these questions are being left open. Well, I heard yesterday that Brian Leiter has visited the university here a couple of years ago, so I may just as well quote him with his naturalistic concept of law. Artifact concepts, even simple ones like chair, are notoriously resistant to analysis in terms of their essential attributes. So he considers, we stop here, he considers law an artifact, an artificial entity, an artificial object. And he claims that these artificial objects resist an analysis based on essential attributes. Why? Because they are hostage to changing human ends and purposes, and because they cannot be individuated by their natural properties, unlike, say, natural phenomena like water, which is just H2O. This seems quite plausible. First assumption, law is not like water. It cannot be identified by a clear systematic of chemical elements. Secondly, law is an artifact, and we will keep this in mind, is an artifact dependent on human ends and purposes. But is the only possible way to speak of an entity as this or that, having this nature and not that nature, having these necessary properties and not those? the only way in which we can identify necessary properties, a natural science perspective, a naturalistic perspective on the law? Or can we maybe develop a way in which we can identify sufficiently necessary elements of law in a humanistic, in a humanities approach? He claims nothing like has ever been successful, and also claims it's useless to look for the necessary properties of law. He also finds, as a consequence, the distinction between law and morality, law and morals, overestimated. Really? Don't we have the need, don't even have courts, the need to identify necessary properties of law and distinguish it from morals? Or look for overlaps, look for combination, look for connection theories between law and morality? For us in Germany, this was an extremely important question. After World War II, there was, of course, the question whether this dictatorial, now it's difficult to find a more general term than law, this dictatorial social order called law under the Nazi regime, whether this was law or something else, mere brute force. And at least for parts of the German citizens, namely the Jewish population, the Sinti and Roma population, people with handicaps, was this social order of the Nazi regime really law? And therefore you need to identify properties, maybe a nature of law, at least a certain form of a concept of law that identifies what is law and what isn't. And this problem reappeared after the end of the communist regimes in the East Bloc, when in Germany the question was, after the reunification, you may have heard that Western Germany belonged to the NATO and was separated by the Berlin Wall and a heavily defended fence from Eastern Germany, which belonged to the Soviet Empire. So after the breakdown of the Soviet bloc, Germany was reunified in a way we don't have to discuss here, but the question arose whether the law of the GDR was really law. And this question became particularly imminent and was broadly discussed amongst German scholars in the question of the Mauerschützen, the shootings of GDR, German Democratic Republic soldiers, on persons who want to leave East Germany. So after the breakdown of this socialist regimes, the question arose, were the commands given to the soldiers law? And was what they did when they shot the refugees from the GDR, was that law enforcement? Or was that simply arbitrary? And to decide this question on the theoretical level, but also on the practical level, you do need a concept of law. One that produces convincing arguments that in the end, it can either incriminate these soldiers, or acquit them. So I think Brian Leiter is very mistaken when he thinks that the question of the distinction or the connection of the concept of law and morality is overestimated. It is an important question. It will come up every now and then, at least in the very situation when an authoritarian regime breaks down, or when you have to decide whether civil obedience or other forms of resistance against an authoritarian regimes are proper. Brian wants, instead of looking for necessary properties of the concept of law, wants to focus rather on paradigmatic cases. How nice, sounds good. Paradigmatic cases. What is a paradigmatic case? How can you decide that a certain case is paradigmatic if you don't have a concept of law identifying necessary or important aspects of the nature of law? It could be paradigmatic for something else. So I think in the end, it's fair to say that a concept that even a naturalistic approach, which can be legitimate in itself, but even a naturalistic approach needs a concept of law. So we also have approaches, of course, trying to take into account the objection that law is not a natural property, like H2O, like water, but an artifact. And I think Friedrich Schauer, who recently died, he had spent his later days at the University of Virginia, previously teaching freedom of speech at Harvard. He starts from the observation that law is in fact an artificial project. And he still is skeptical. Law cannot be cut down to a definition, but only to a typical description. This is close to the family resemblances H.L.A. Hart was speaking of. So he identifies the nature of law not as an assembly of necessary and sufficient properties, but of typical elements that could identify law in many cases, but not necessarily in all cases. It is remarkable, however, that supporting his argument, he uses examples from nature. He speaks of non-flying birds. So the concept of a bird typically refers to the possibility that this animal can fly. But of course, there are penguins and others who can't and are still birds. So the ability to fly is not a necessary, but a typical element because they are non-flying birds. Another approach, however, would be, I mean, when you think of birds, you obviously think of flying birds. But maybe we are wrong. Maybe there are different properties that all birds share. Not flying, but not feeding their children, but producing eggs. So, and maybe there are properties in this sense that all birds share. Well, Schauer wrote in his book, I think it was The Force of Law, maybe a different one. I will suggest only that whatever the status of essentialist understandings of the concept of like triangle and goals, such understandings may be inappropriate for the concept of law in the same way they may be inappropriate for concepts of art alike. So I find this very appealing in the sense that he doesn't completely give up the search for a concept of law, but claims we have to apply a different approach for artificial projects, artificial entities than we apply for natural entities. So he shares with Brian Leiter the notion that we have to distinguish between natural entities and artificial entities, but he doesn't share Leiter's skepticism about the possibility of a concept identifying typical elements for artificial artifacts. However, if you have typical elements, you cannot identify essential elements in the sense of a nature of law. And for him, force, not authority, but force is a typical, not necessary element of law. Now, wait a second. Is force a typical element of law? Can most of laws be enforced? Okay, we might agree to this. Skeptical about international law, but for a typical set of elements, this would suffice. But we could also turn the question around. Are all forms of law, are all forms of force typical for law? Is it really typical for our modern law to take into account the cultural relativity of the concept of law advocated by Joseph Raz? Is it really typical for our modern law that force defines law? Could we say, for example, that a norm is law if in general it's being enforced? And would all form of force make a norm law? I'm hesitant to answer this question with yes, because there are definitely forms of force. Our laws in Brazil, just as well as in Germany and Austria, in Europe and North America, and in most parts of the world, forms of force that are illegal. Our whole modern law is about distinguishing between legitimate and illegitimate uses of force. And of course, but Shaw could agree to this, there are forms of force, forms of law that cannot be enforced. So let's maybe keep this for later, a little skepticism that all forms of force are capable of identifying typical properties of law. And another aspect concerning his skepticism about the possibility of identifying necessary elements of law. Is it really true that if an entity is empirically opaque, has blurred delimitations in reality towards other phenomena, that make it impossible to speak of the nature of law? Are we, in our epistemic apparatus, in our possibility to understand, dependent on the objects we want to analyze, or are we independent? Maybe if we have a sufficient epistemology, our security comes not from the necessary connection between our concepts and the objects we are going to analyze, but from the coherence of our epistemological theory. And in this sense, concepts are not meant to represent reality, but to give reality a meaning. Again, I'm going to come to this aspect later. Now, I skip a few theories that warn us from developing a concept of law. For example, Judith Sklar, an anthropologist, legal historian, she says, don't develop a concept of law because its delimitations may be so strict that you overlook alternative forms of law. Forms like indigenous social orders, early historical forms of a social order that could be called law. I wouldn't consider this an obstacle, and I wouldn't share her skepticism and her worries that this could be dangerous if we develop a concept of law that is broad enough to encompass early forms and, let's say, indigenous forms in general of the concept of law. So far, I hope I could raise some skepticism about the skepticism of the concept of law. This, of course, does not justify to straightaway speak of the possibility of a concept of law. I now come to the aspect or the main part, how could we develop a concept of law? But let me summarize what we have found so far. Law is indeed not a natural artifact, and jurisprudence, legal theory, cannot develop a concept of law like sciences would. This, however, does not render the possibility, the impossibility of coming to a concept of law. There can be a concept, it makes sense that we look for a concept of law, identifying at least the typical properties of law. There is also the necessity to come to a concept of law capable of distinguishing law and morality conceptually, even if there is a certain connection or if there isn't. And for this, let's look a little bit into epistemology, because in the end, I sketched or gave a perspective that with a certain epistemology, we could come to a concept of law. Now, if law is a cultural artifact, maybe a cultural approach leads us to a proper concept of law. And a philosopher who advocated such an epistemology was Immanuel Kant, but many others following him and some preceding him. Now, what is the interesting aspect of Immanuel Kant, the German philosopher? I hope you not only learned about the Americans, but also about this philosopher from Königsberg in Prussia at the time, now Russia. Immanuel Kant, in his famous critique of pure reason, but also in the critique of practical reason, finally in the metaphysics of morals, first part, the metaphysics of law, metaphysical elements of law, he criticizes our common understanding of perception and our common understanding of knowledge. In a naive realism, we think we know about the objects by perception. And I hope that you have the perception that you think I'm really here, that you can see me, or at least listen to me or looking at me. But what makes you sure I'm really here? The perception. And Kant says in the critique of pure reasons, knowledge, gaining knowledge, has two elements. One is perception, which is passive. You would see me even if you half fell asleep, which you may do if I talk too long. One is perception that is passive, and the other one is an active element. If you would only perceive what you see, you would perceive a number of colors, maybe, black and white. And these colors, you wouldn't even identify as colors. You would see black and white moving, uttering some noises. But if you wouldn't start thinking about what you see and the noises I make, you wouldn't even identify my bad English and not understand the sense, if there is any, of what I'm saying. This understanding, this comprehension of the perceptual aspects you see and hear, maybe smell, this understanding comes from your own activity. And here's the problem. Perception is quite objective. But our activities, as we all know, are subjective. We have to produce our thinking. If you don't want to think, this is the wonderful aspect of universities. If you don't want to think, you get no knowledge. You get no insights. So we are all responsible. It's in our free will whether we want to understand, whether we want to combine, to form our perception, or whether we don't. And since it depends on our freedom, whether we want to construct our reality out of perception by our thinking, it can be subjective and it can be wrong. So the wrong knowledge does not come from our perception. It's not a question of the relation of our thinking towards our perception, but it's an issue of our thinking itself. We have to apply the right methods. And I think this is the great insight from Kant's critique of pure reason. Mistakes, wrong judgments about reality are not a matter of perception, but a matter of the wrong method of the interpretation of the perception, of the connection of concepts we create in our thinking. Of course, we have many associations that work wonderfully. You have seen so many professors from different countries standing in front of you that you know if someone in black and white, something in black and white is in front and utters some noises, it's certainly a professor telling you something about the theory of law. This comes almost natural. But if we criticize, if we analyze how this works, and this is what Kant does, we can see that the judgment that this person, this entity is a person, and this person is a professor teaching about legal theory, is your construction. So your construction is what provides the knowledge. This could lead to an, what Kant calls idealism in the Berkeleyan sense. You know, you may consider now that everything is a dream. There is no reality, because all is your subjective construction. But Kant says, if we follow certain methods in constructing the world, this method provides us the objectivity of our knowledge and the appropriateness. Well, of course, one could elaborate much more into this. I won't do it here. What we should keep in mind is that although objects may be irrational, may be opaque. This doesn't hinder us from making scientific judgments about these objects. Otherwise, for example, psychology would not be possible. So the vagueness, the openness of the texture of an object does not determine the knowledge about this object, does not determine the impossibility or possibility to make conceptual assumptions about these objects, to even talk about the nature of the object. So if we talk in a Kantian sense about the concept of an object, concept of law, we don't make essentialist claims in the sense of medieval metaphysics, but we identify necessary elements of this object, which necessarily stems from the logical coherence of our assumptions. This is a completely culturalist in opposition to naturalist concepts. So Brian Leiter would have left the room by now. He does not agree to this concept. But Kant calls this a transcendental concept of law. He tries to answer the question, what are the conditions for the possibility to develop a concept of law? And these conditions are different for natural entities and for artificial entities. The reason for this will be given later. But Hans Kelsen, the famous Hans Kelsen, Austrian's most important expert in legal theory from Vienna, however, and from Berkeley later on, Hans Kelsen works with this transcendental approach to the knowledge of law. He particularly, at least in his second phase, the first phase referred to Windelband, a German general philosopher. In his second phase, and especially in the first and the second edition of his Pure Theory of Law, asked the question, what are the conditions for the possibility to understand law? And then he starts, for example, with policemen giving you a ticket for parking at the wrong place. Is this law? Well, and you all know this is law if the norm admitting the policeman to do so is law. It is not because of the fact that the policeman enforces a command, but because of the normative structure of the reasons he is given. And then you go up the ladder of normativity up to the Constitution, and then the question arises, well, is the Constitution law? And as you know, he invents the basic norm. If we don't want to fall prey to the naturalistic fallacy, all reasons in justifying an act as a normative act have to be normative and not empirical. So the question, why is the Constitution a norm, may not be answered in a Schmittian sense because it is a decision of the supreme power, let's say the constituent power, but because it can be explained by a pure norm. So the pure norm is the condition for the possibility to understand a legal order as a normative order. And this pure norm as an assumption, not as a reality, not as a real norm, this is very different from Hart's rule of recognition. In a transcendental approach, the ultimate criterion for understanding a normative order as a normative order, as an order of norms, must be a norm. And he creates his basic norm as a pure norm, meaning that this norm is not based on a decision, but based on an assumption. All norms in a legal order are based on decisions, which is a factual element. But if you don't want to fall prey to the naturalistic fallacy, you may not deduce a norm out of a fact, but only from a norm. And the precondition for this in his transcendental approach, Kantian approach, is the pure norm. So for Hans Kelsen, the concept of law is possible if we refer all norms to a basic norm, the Grundnorm. Another Kantian, by the way, is Gustav Radbuch. I'm not sure if you have heard of him. Gustav Radbuch became very influential. He also referred to Kant, but whereas Hans Kelsen explicitly learned from the Northwestern New Kantians like Hermann Cohen and others, Nathorp, Gustav Radbuch referred to the Southwestern Neo-Kantians. The Southwestern Neo-Kantians, like Windelband, said with regard to cultural properties, the condition for the possibility of understanding an artifact is its relation to a value. So whereas Kelsen is more formal and says the condition for the possibility of understanding is its reference to a norm, Gustav Radbuch says the condition for the possibility of understanding law as law is its relation to a value, and this value necessarily is justice. Justice in a very formal sense. But it leads him to a more substantive assumption of what law is. So what we take from this is to be capable of developing the concept of law, we should not stick to our perception, because this would ultimately miss the important point. It would provide a naturalistic concept or the impossibility of the concept of law. We have to refer to our epistemic apparatus. We have to refer to the active thinking and the methods of this active thinking. And this is also appropriate because law is an artificial product. Now let's make a little detour to medieval time, to Renaissance time. In a wonderful treaty, Salutati, a 14th century philosopher, spoke about the preeminence of jurisprudence over medicine. Well, this is for our self-understanding as lawyers, of course, very important, that we are better with regard to science than medicine or other sciences. Why could our epistemology, our knowledge, be more profound than knowledge in the sciences? We tend to think it's all subjective in the arts. We tend to think that sciences have wonderfully objective apparatus to analyze their natural entities. And even sociology can make empirical studies which are objective and appropriate. Yes? But if we follow the path of Immanuel Kant, then, as I said before, objectivity does not come from perception, but from our construction, from the appropriateness of our construction. We don't perceive the truth, we construct the truth. And the objectivity of our judgment about the truth stems from our methodology. And Salutati contributes to this point Because he says, why is it that in the humanities we have a better knowledge of our objects? Because we create them. And Jean-Baptiste Vico further elaborates to this point. He says, what we have created is not foreign to us. The tree is a tree without any human being. And when we analyze it, we always have an external point of view. We can reconstruct the natural laws that created this tree. But in the arts, and especially in law, we have an inside perspective. We know where the laws come from. And in a democratic society, we are even more privileged because we are participants in the creating of the norms that then lead us. This gives us an insider perspective much closer to the epistemic object than with regard to natural sciences. And this is why hermeneutics are in place. Hermeneutics from Dilthey, Gadamer, Esser, and also Ronald Dworkin. We have to enter into the process by our knowledge in the process that created the norms we are subject to in order to understand law. So as a consequence, for our science, legal philosophy provides the legal bench, as Immanuel Kant says, which is very interesting. In his critique of pure reason, many times he uses legal institutions as given examples. He speaks of the legal bench of reason, the tribunal of reason. So in jurisprudence, we have a privileged form of knowledge, it seems. We think in legal philosophy about what lawyers do. We think about juridical thinking. This is, I think, the task of legal philosophy. If we follow Georg Wilhelm Friedrich Hegel. And thereby, we can develop a concept of law. We can evaluate the concepts of law that have been produced by different cultures and maybe build an overarching concept of law. Concepts thereby are not essentialist concepts, but they can still provide a nature of the law when we analyze the concept. A nature, an assumption about the nature of law stemming from the necessary connection of its elements. I think I'm going to skip this and come back to the critical understandings of law. Now, if we do this and we look at the landscape of theories about what law is, very roughly, you remember Friedrich Schauer said the typical nature of law is that it is enforced. The force is a typical criterion. Ras speaks of legitimate authority. Robert Alexi criticizes this and says there is a double nature of law. Law is not only facts, but also has a normative aspect, namely the correctness or the rightness of law. So law is a norm that is being coerced, that's being enforced, and has a normative aspect, its correctness, its rightness. But how's the relation of the two? And what kind of correctness? Where do the criterion of correctness come from? He comes with the Radbruch formula, that certain massive violations of human rights would render law, an enforced law, non-law or unjust. In his formula, maybe we come to this in the discussion, distinguishes between non-law and illegal laws. But Alexei, and I think also Dworkin, have to justify which form of justice, which concept of justice can render a certain norm illegal. And Schauer and Raas have to give arguments which forms of force make a norm law and which don't. Which forms of authority are legitimate and which are not. And if we look at modern law, it is the law itself that defines the procedures, the competences, and material limitations that have to be observed when commanding a norm and when enforcing a norm. So if these normative criteria regulate which form of enactment are legal and which forms of enforcement are legal, which forms of authority are legal and which are not, then it is not the force of law, not commanding the law, not the authority that makes a norm law, but the other way around. Law defines the criteria for appropriate commands, for a legal form of enforcement, for a legal authority. So not the factual element determines the normative element, but the normative element determines the factual one. And against Robert Alexei, I would say, we have, since, if we start a discussion, what you think justice is, we probably came up with very different concepts of justice. And if you would ask the citizens about their concept of justice, in a pluralistic society, you have so many concepts of justice. It is the duty of our legal system through public discourses, democratic discourses, to identify those elements of justice we find for ourselves and maybe for the international community as important aspects of justice. And then for us, this is justice. And this public discourse, again, is shaped by norms, by legal norms. So again, it is not justice that defines when a norm is law, if a norm is law. But it is the law that defines the process by which we decide about our concept of justice. And this is why in the end, I would say, based on a transcendental approach, methodologically based on the transcendental approach by Immanuel Kant, I would say law is a reflective norm. A norm is law if its enactment and its enforcement is regulated by other norms. So if you want to, you could say that law is a normative norm. It's not merely a norm. Hans Kelsen wanted to reconstruct the legal order as by a pure norm. Thereby he could only explain the logic of a legal order. judging that it is purely normative. But it isn't. And it's also not purely factual. It is, as we saw from the discussion of the previous authors, not a natural entity. It is an artifact, but different from artifacts like literature, like music. This artifact, this artificiality, follows in its emergence, follows norms. So in the end, law fulfills the same function as philosophy does for knowledge. Philosophy is, in Aristotelian sense, in the Kantian sense, a thinking, a theoretical evaluation of our thinking. Or in Aristotelian sense, a noesis noesios. And law does the same for our society. It is producing normative norms. And now you were way too polite to listen to my considerations for the whole time without interrupting me. Thank you very much. That was also my result, and we have the first question already. Thank you very much.
I was wondering, yeah, stay loud and recording. Oh. Thank you, Professor. Very interesting. I was wondering, while you're talking about norms, you said that law is a norm that refers to another norm, right? So where does it stop? Is your solution similar to Kelsen's presupposition? If you follow the structure of hierarchy, where does it stop if you have to refer to another norm?
Okay, this is a very good question and an obvious one at the same time. I'm not presenting the same solution as the other Austrian Hans Kelsen presents. No, because Hans Kelsen reconstructs law by a pure norm. He follows Adolf Merkel in the so-called Stufenbau der Rechtsordnung, the hierarchy of legal norms. And he comes to the problem, if we explain the normative reason of a law from its higher norm, from the normativity of its higher norm, we come to an infinite recourse, as you have well described. And therefore, he presupposes the hypothetical or fictional Grundnorm, basic norm. In my construction, all norms are law if they are the result, if their enactment is the result of a normed process and not a mere arbitrary decision. And the enforcement of this norm, if there is an enforcement is not necessary, and maybe legal norms that are never being enforced, is normed by procedural norms, including the interpretation that follows certain normative preconditions. So at each step of the legal order, you could ask the question, is this a legal norm? If you refer to the procedural norms, these procedural norms in my system need not be law. So if the constituent power says, there's a sovereign ruler enacting a norm, and he does so by giving him a normative procedure in which he will enact the Constitution. Then the Constitution is law. Although the norms this Constitution stems from may not be law because he, the ruler, decides about the procedural norms. And the same applies to all steps in the legal order. What is not law is, and this was the case about the Nazi laws justifying the sterilization and the killings of human beings with mental handicaps. Adolf Hitler woke up in the morning, no, he was very lazy, reportedly, so he woke up at noon, talking to his secretary, Bormann, and telling him, these imbeciles have to be sterilized. Is that law? No. There's no competence norm, there's no procedural law admitting this. And of course, it's unjust, even given the few enforceable fundamental rights from the Weimar Constitution. This is not law, because it's not a normed law that Hitler was uttering. And to come back to Sklar's objection, aren't we excluding indigenous laws from the concept of law? No, we are not. The state, in my definition of the concept of law, is not a necessary element of law. We don't need a state authority to produce normed norms. Just the other way around. And here I follow Hans Kelsen. A state is a state of law, a legal state. You know, in German, we have the principle of the legal state, which has many similarities with the principle of the rule of law. But a state is a legal state if it is built on the Constitution and if its competences are limited by the Constitution. So law defines what a legal state is, and not the state defines what law is. And therefore, we don't need the state for law. There may be indigenous forms without the state, that indigenous forms of social order that can probably be called law if, let's say, the oldest member of the tribe has been given the competence to decide about quarrels between the members of this community.
Just a follow-up. Thank you again. So yeah, if there is a procedure, even if it's an indigenous society, if they have a procedure, they have law. But how does it fit, for instance, customary law?
Just
customary customs.
Yeah.
How do we? There's not necessarily a procedure for something that's built over time. And how do you fit this into the scheme?
Okay. This is, of course, a very tricky question. Tricky also, because it brings me into the uncomfortable position to decide a quarrel between two Austrian scholars about what is customary law. I don't know if the name Eugen Ehrlich is familiar to you. He is most famous for his legal pluralism. And his legal pluralism is partly based on a certain theory of customary law. So, whereas Eugen Ehrlich says customary law is a certain social practice, the necessity of which is considered binding for a certain community. And if this community considered is binding, then it is customary law, not only a certain habitual practice. Hans Kelsen has a different approach here. He says it only becomes law if the competent court in a procedure acknowledges these norms as law, these habitual norms as law. So he limits the acknowledging subject to the legal institution. I would say that whenever there is a procedure for the acknowledgement of certain habitual practices as binding, an acknowledged practice to identify which practices are binding and which are not, then the result of this procedure is customary law. So customary law is not merely a practice, and the mere fact that the respective community acknowledges this practice as binding doesn't make it customary law, but only if this recognition follows a normative procedure. Let's say the community meets and says we have here find a certain practice which contradicts another practice, which is law, and they always do it this way, then it would become law. So again, even customary law is a normed norm. Maybe not fully convincing, and you have some further remarks on this. Or maybe not convincing at all.
Thank you, Professor Kirst. Thank you very much for your talk. Very enlightening, and I think it's a really good summary, critical summary about the state of art, about conceptual work in law. But I wanted to ask you about this. You didn't explore very much the hermeneutical approach to law.
No, not at all.
I think your view is more like a Kantian / Kelsenian view on law, in the sense that the concept of law comes from a rational reconstruction about the practice, and so law is norms, basically, it's norms. But isn't this a very theoretical approach? Because I think that norms are reasons for action. Norms tells you what to do, and reasons, at some point, they must be moral. There are only true reasons. They can be apparently true reasons with law, and we follow this based on this. But if they are reasons, I think the law is not really a descriptive, even in a reconstruction, rational way, but in a thick way, a thick concept, in the sense that we understand law not only understanding what people actually do, or officials actually do, or even what they actually say that the reasons are. So like Hart would say, we go and see that people have many reasons to follow law, but also understanding what law is for. What our self-understanding says that we use law today for. And that would be our concept today. So, for example, law wasn't all the time used for guaranteeing freedom and autonomy. There's a evaluative aspect of law today. So we don't accept every authority. That's why RAS starts from a legitimate authority, and then goes to the apparently legitimate authority. He's kind of implicitly adhering to this self-understanding that is from our time, and that it's almost always implicit in our understanding of law. We don't accept a law like the military dictatorship we have in Brazil, where there was Esquadrões da Morte.
Yeah, that's squadrons.
They were officials, many of them, but we don't see that as law. And by the other hand, we have also structural aspects that are implicit today, in the sense that law works mainly through the state and maybe through international relations, also international institutions. That was not always like this also. Even in the modern state, we all didn't have always civil servants, for example. But today we have bureaucracy. So I think this would be a hermeneutical approach that would be different from a rational reconstruction, would be evaluative, would be practical, and would be historical in a sense too. I don't think that this rational reconstruction, I think that it misses some things, at least, for our understanding of law. Wanted to hear more about it.
Okay, I admit that I don't follow a historicist. I would call it a historicist without a negative connotation. In the sense of the 19th century, the 20th century hermeneutics, I'm not following this approach, though I think it is helpful because it tries to develop adequate methods for the understanding of artifacts. And here I have the highest regard for Beck, for Dilthey, for later also for Gadamer, Heidegger, that they are looking for the adequate methods to understand human artifacts. And by the way, Heidegger studied in Marburg the center of neo-Kantian constructivist theoretic approach. If you apply such an historicist method, what do you do when you deal with social orders of the past that don't match your contemporary concepts of law? I mean, if you were consequent, you would have to call those non-law. And the more progress society makes and reaches new practices that will be evaluated based on historicist hermeneutics, the quicker you come to the judgment that previous social orders are non-law. And if you seem to want to apply a functional approach, let's look at what function these social practices are intending. But if the function would be the same or similar, or at least have a few properties in common, you would need an overarching concept to identify common practices at law and historical practices at law, and also deviations from that. An example you gave was Joseph Ra's concept of legitimate authority as an important property of the law. And here, he and you claimed that in whatever historical times means, not freedom, liberty was the ultimate goal of law, but authority. Now, what is authority? And what is legitimate authority? Is authority, does someone have authority if he or she has the supreme power? Or only if the supreme power follows certain reasons which make this utterance of power legitimate? And how is power related to freedom? Maybe we can reconstruct this historic authority, this historic legitimate authority, by freedom. This is exactly what Hegel does. Hegel, by the way, a very historicist philosopher, but one that found overarching reasons in history. And he said, history is progress in the concept of freedom, in the consciousness of freedom. Geschichte ist Fortschritt im Bewusstsein der Freiheit. Very difficult sentence, as most sentences of Hegel are very difficult to understand. But he, based on this sentence, this assumption that history is process in the consciousness of freedom, he said the ancient, Oriental ancient, whoever they are, had the notion, had the understanding that only one person is free. And this one person is the legitimate authority of the society. So we can reconstruct authority from freedom and then keep up the concept that law is intended not only to protect freedom, but also to be an expression of freedom, because authority itself means a certain use of freedom. So in this line, I'm not advocating Hegel here, but in this line we could try to reconstruct different historical conceptions or different historical understandings of law based on very general concepts, values principles, which would give us an overarching structure. And now, another aspect you mentioned was, you said that the concept of law is about reasons. Why do you speak of norms? Because norms shape our reasons. What is a norm? In Kelsen's words, it is a sentence containing an ought. So we have descriptive sentences and we have normative sentences. The fact that I'm still speaking, although I should finish, you can describe this, and I should finish would be the normative sentence. And what is an ought here? What is meant by an ought? It's a duty, a prohibition, or a permission. And these deontological modes shape the reasons we can give in the enactment and the enforcement of laws. Some are permitted, some have to be given, some are prohibited. If we apply torture, for example, most legal order prohibit the use of torture to find out the truth. We may describe the impossibility to find the truth by torture. If you torture a legal philosopher, he says anything to stop the torture right away, not necessarily the truth. I'm more telling the truth if you don't torture me. But this is very descriptive. And the normative sentence would be, torture should not be applied because it violates human dignity. And in this later sense, norms and law as a norm filter the reasons possible to justify public authority or private action. So it's true, I would fully agree that law is about reasons, but a certain group of reasons. And we have to reconstruct not only the kinds of reasons given, but the form they are given to us. And the form is normative. I'm not saying that different approaches to the understanding of law as a social practice, as a social fact, even as a natural entity, could be interesting. But from the point of legal philosophy as an analysis of practiced legal thinking, I would take the normative approach based on the given reasons.
Thank you, Rebecca.
Thank you.
Thank you, Professor. Thank you for your presentation as well. I have a question that's sort of a follow-up question to what Renato asked, because you've mentioned that law is a reflective norm, and a norm is law if its enactment and enforcement is regulated by other norms. My question here is regarding the examples you gave. You've mentioned that Nazi law wasn't law because one morning Hitler decided what he wanted to do and asked for someone to enact a law. But then you said that your concept could encompass indigenous law, which would be based on the, I don't know, the oldest person in the place has the say. But what's the difference here? Because in the Nazi regime, maybe the dictator had the say, and in the indigenous organization, the oldest person has a say. Mm-hmm. How do you differentiate those two examples? Like, why one has a normative aspect and the other one has not?
It's such a privilege for me to have so good questions, and also to be reminded in aspects I promised to talk about but didn't. Nazi law. The example I gave were the so-called laws for not ethnic but what would you say, health cleansing of the German race. And they were only decrees made by Hitler, not based on any procedural competence or other norm. Although Carl Schmitt, in an early article after the so-called Röhm-Putsch, said der Führerwille ist oberstes Gesetz. The will of the leader is the supreme law. This has not been generally accepted as a justification of Nazi laws. Nazi laws still tried to achieve or pretend to have some legitimacy by following the processes, legislative procedural rules of the Weimar constitutions and respective laws. So in general, the assumption was that only those laws can be laws which, parliamentary laws, which have been decided by the Reichstag in appropriate procedures. So the other example one could use are the so-called Nürnberger Rassegesetze, the statutes given by the Nazis on the German race. In these laws, the Nazi legislator decided that there would be different legal statuses of German citizens. Full status, not only protective rights, what had been left of fundamental rights, but also duties, would only be given to the Aryan Germans. Jews and other minorities would have a much lesser status. And also, these laws regulated that it would be impermissible to have mixed race marriages. It would be impermissible for a male-dominated household to employ a female Jewish servant under 45. And the reason given here was that these laws should guarantee the purity of the Aryan German race. What a reason. These laws were prepared very urgently by the Ministry of Justice and discussed at the party convention of the NSDAP in Nuremberg. And even Nazi lawyers were aware of the fact that the NSDAP could not decide about laws because this would be the job of the legislator. So despite the Weimar Constitution asked for or ruled that legislation is possible only in the Reichstag in Berlin, the Reichstag was called to Nuremberg, and there they decided about these race laws. Now the question is, are these laws law? Are these norms law? Incredibly unjust. Decided upon in the wrong procedure. Or are they something else? Well, most German lawyers, including, for example, Karl Lahrens, Carl Schmitt, thought they would be laws. Somehow they were faulty because the Reichstag decided upon them at the wrong place. But then the question came up after the breakdown of the Nazi regime. Are they really laws? And here Gustav Radbruch developed his formula. If a certain norm is immensely unjust, passes a threshold of a certain amount of injustice, unbearably unjust, then this norm is illegal. And Gustav Radbruch was aware of the fact that this is a very, very vague criterion to distinguish between law and morality, and this is where you were pointing to. He adds, on the one hand, that he assumes that even in Germany at the time, in the early 30s, we have reached a certain understanding of human rights. And if core human rights would be violated, this would justify the threshold of unbearable injustice and render such a law illegal. And based on this, one could say, and some German courts in fact did, reluctantly, however, estimate that the race laws would be unbearably unjust and therefore illegal. But Radbruch also gives a second criterion. If a norm, an enacted norm, is not directed towards the idea of law, then it is non-law. Now, if it is not directed towards the idea of law, what does it mean? The idea of law is justice in the core of justice. So Radbruch distinguishes in a very subtle way between the validity of law. A norm can be conceptually law, but being void, having no validity, if it contains an unbearable amount of injustice. So for him, the Nazi laws were illegal. They were law. Conceptually, they were law, but illegal. One could argue, however, that these Nazi laws were not even directed at the idea of law, not even directed as at justice, towards justice. Especially if you consider, for which there are obvious reasons, the race theory as irrational and no concept of justice. So in this sense, we could distinguish between different forms of Nazi law. Some of them, like the decrees on the extinction of human beings with handicaps, mental handicaps, are non-law, in my terms. And the race laws, which in my understanding would be law, because they follow a normed procedure, more or less, faultily, they are laws, but they contain an incredible amount of injustice, and therefore they wouldn't have moral validity. In Radbruch, according to Radbruch, they wouldn't have legal validity. Only moral validity is lacking. So I think with the concept of a normed norm, you can handle these cases. And there is still a distinction possible between Adolf Hitler following no rules acknowledged by anybody and not even having the will to follow any rules when uttering his decree, and an indigenous procedure, whereas a kind of, maybe customary law says that if we have conflicts, we go to the eldest of this community and he has the competence to decide a certain conflict. I hope this was not only long, but also answered your question. Sorry. Yeah, it's, I mean, in Germany, the Nazi case and also the GDR norms are still very imminent cases. And we talked about it yesterday, also the reasons why Germans are very reluctant to call the genocide against the Palestinians a genocide based on no laws whatsoever. But I think given our past, especially with regard to the Jewish population in Israel, we shouldn't be the first to criticize the Israeli government. But altogether, my lengthy answer explains why.
Thank you, Professor. I'm a freshman here at USP, and legal theory is a new subject for me, and I really like it. So I would like to thank you for your lecture. And I wrote down my questions so I don't get lost. And when we revisit antiquity, the Middle Ages, we have very clear notions of what law is. And now in modern times, we see increasing liquidity and uncertainty in both social procedures and personal relationships. In this sense, the German sociologist Niklas Luhmann deals with the notion of social subsystems that arise precisely from the complexity that is the result of modernity. Consequently, these subsystems condemns them to a dichotomy, such as in law, legal and illegal, which, in my view, ends up contributing to the superficiality of the concept of law. What the concept of law is, and as a consequence, its legitimacy. So, in your opinion, what do you think are the consequences of not being able to determine what law is, given the instability of modernity? For instance, like threats to the moments.
Mm-hmm. Okay, thank you very much also for referring to Niklas Luhmann, which who was very important in my long development of my legal theory. Well, I advocated the possibility to determine a concept of law and even identify necessary properties of the concept of law, namely that it regulates the enactment, interpretation, and enforcement of law. Now, this is a very Kelsenian inspired approach. Not that Luhmann didn't draw from Hans Kelsen, but he gave it a very different twist. And namely, his approach is a sociological approach. So social systems are not only social practices, social action based on social action, but are communicative systems. Whenever a communication takes place, and he further defines what communication is, then we have social systems. And in the process of differentiation in modernity, as you well describe it, functional social systems developed, working, and this is the aspect that is important for modernity, independently of human beings. There are forms of communication, whoever communicates according to the concept of communication. Now, different functional social systems have emerged from this general concept. We have the economic system, the political system, the education system, and the legal system. Now, how do we distinguish those systems? You know that, of course, there's a basic code, a binary code. And for Luhmann, this code is Recht, Unrecht. And I'm not sure if I'm permitted to translate this as legal, illegal, or law, non-law. Probably legal, illegal is the appropriate interpretation of this. So whenever a communication is led by the code, legal, illegal, it is part of the legal system. And this legal system is further concretized by certain programs like laws or other forms of communication. This is a completely different approach You know, it's a historical, it's a sociological, supposedly descriptive approach, although his theory is, of course, a constructivist theory. And in some cases, he comes to different understandings of law. He's able to shed light on different phenomenon than a normative approach. So I think we don't contradict each other, but it's rather a supplementary perspective on the law. As I said, knowledge is our construction, our methodologically led coherent construction. And Luhmann provides the concepts of a very, very coherent system of knowledge, but based on the elementary concept of communication and not on the normativity. I think for legal philosophy and not sociology, the concept of norm is more adequate. But that doesn't mean that what he has written about is very insightful. Maybe I leave it with this very general remark. Yeah, your question is also interesting because I had the feeling that after Luhmann's very early death, his prominence would diminish, but I'm now optimistic that he won't be forgotten.
Thank you, Stefan. Very, very, very interesting and very illuminating presentation. Just one comment and then two questions for further considerations of yours. First, it seems that in the very beginning, when we were discussing the concept of concept and the possibilities and the way you describe the, let's say, the flaws of Hart's approach, I'd say that it seems that we could still argue that there might be a non-essentialist way of trying to approach the concept of law, because I do agree with you. I mean, if you take the essentialist definition of a concept as the only possible one, even the title of the concept of law will be contradictory in a way. So,
yeah.
But I think that he's arguing there that it is possible to describe a concept in a non-essentialist perspective. And it's interestingly, the very idea of essence that appears in some of his writings, and you note that he quotes this idea of essential features of law in the postscript. But I don't think that he has changed his mind. It's probably using it in a different way. I mean, as much as, for example, we were discussing this yesterday, Wittgenstein's strong, very direct attack on these essentialist perspectives on how to define the meaning of the concept. Or if one hand he delivers this strong attack, in other passages he uses comfortably the concept of essence. And this is not to say that it is, but those other concepts he's using in a different, with a different meaning assigned to the very idea of essence. So a non-essentialist use of the word essence, so to speak. So my two questions, which I'd like you to like to hear more about them, is first, you in your lecture you use the word norm and normativity, and I would like to know if you make any distinction between this idea of norm and the idea of rule. And the reason it's also connected with this kind of possible Wittgensteinian background on how to define what a rule is, understanding a rule that is always somehow connected to some practice. And I think this is connected with what Martin also mentioned. A rule, according to Hart and also Wittgenstein, it's rooted, it's embedded in some kind of social practice. So it's not something that is a mental understanding. So it's a complete different understanding of what the rule is if you compare to Kant, for example. The rules of thought in Kant, it's something completely different. So my question here is, how would you first define more clearly the idea of norm that you use in your presentation, and is there any difference between this idea and the idea of rule as, for example, adopted or used by Wittgenstein or Hart? And finally, this course is on philosophy of international law, so I wouldn't miss the chance to ask you, what about the concept of international law, especially nowadays when the idea of the use of force sometimes create some kind of challenge on the very concept of international.
Okay, too far-reaching questions, too difficult questions also. Well, to make the answer to the first question, relationship between norms and rules short, I would consider rule a norm. Rules are norms. Certain norms, and I'm afraid now I'm trapped by the German interpretation of Hart and mostly Dworkin. We distinguish, of course, rules as definitive norms from principles as optimizing norms. So I would distinguish rules from principles, but under the umbrella concept of norms, because both tell us what to do, what to refrain from doing, and give permission to do certain things. Only the rule in a definitive way and the principle as an optimizing principle. So I'm afraid I follow here Robert Alexi more than I would follow Hart in the descriptive understanding of the rule. And also this brings me to a Kantian a point I would like to make here. If we describe practices, we tend to describe them as factual facts, as social facts that follow certain rules, certain regularities, which are forces behind the practice of the citizens, the practice of which is in question. It seems to me that there is a naturalistic or sociological concept of the relationship between the general laws that determine our actions and our action behind this. Therefore, the descriptive approach is in place. But this ignores the fact that through law, I'm coming back to your question. From the beginning, law was intended to take the place of natural laws in the sense of the sciences for human beings. Natural laws determine us. Natural laws determine the entities which they rule. Human laws give reasons why we may or may not, which we may or may not follow. This is a completely different relationship. So norms address our freedom. The freedom to act legally or illegally. And our freedom, because the norms we are following are norms we have deliberated publicly. Which is a very remarkable thing if you think of communication in social media. Many of us may think that our communication in social media is the ultimate form of liberty. The internet, social media are, or should be, a law-free space. Elon Musk advocates this theory. Is that true? No. Algorithms steer our form of communication, stir up worries, amplify sensational utterances. So there is a certain path dependency of laws, algorithms, which we have to follow when communicating in social media. These are not expressions of our freedom, and they are not directed at our freedom. Political communication in the past, and hopefully in the future as well, are regulated by norms, by legal norms. They are not free in the sense that here is a law-free space. They are regulated by communication laws, limiting our freedom of speech, maybe sometimes too much, but are expressions of the necessity to balance our freedom of expression with other fundamental rights or human rights. But the way of this balance is an expression of our deliberation. So norms are expressions of freedom and directed at freedoms, whereas algorithms are laws in the sense of natural sciences determine us. And sometimes I'm afraid that the concept of rule is closer to a naturalistic understanding of social practice than an humanistic understanding of human practices as artifacts. And this is what I wanted to elaborate in my presentation, that we have to find adequate forms of knowledge for these artificial forms of human practices. And therefore, probably, but in the end, you know this better than I do, I have a different concept of rule than H.L.A. Hart has. The second question concerned the topic of the course. I was not familiar with that, sorry. And also, I'm not an international lawyer. But if we look at the history of international law, if we go back to Grotius, the whole aim of jus gentium and the transformation from its natural law form to its positive form was to rationalize the relationship between states, to rationalize even the most irrational behavior of states against each other, the war, to norm the beginning of the war, because at least it has to be declared, and there are justified reasons for war and non-justified reasons. So an aggressive war, like the war in the Ukraine, is not justified. It doesn't follow the acknowledged norms. And also the war itself should be subject to norms. And if we look at the Gaza war, the genocide there, it doesn't follow the norms of international law. And finally, the end of the war should be a treaty, a legal agreement that marks the end of this factual, merely a factual relationship between states. So the attempt of international law was to rationalize the relationship between states by legalizing it. And in this sense, we must say we are in a very precarious situation right now. International law, in this and in many other senses, if you look at American politics, simply ignore laws because of their power position. There could be a slippery slope in the deterioration of the international legal order we were accustomed for not only the post-war World War II period, but since the Westphalian order. I mean, if Trump really wants the Ukraine to acknowledge that Russia has seized parts of its territory, although it is unconstitutional with regard to the Ukrainian constitution. It's clear that he claims for superiority of politics over law. The whole development of modernity was to acknowledge the difference between the political system and the legal system, but base political decisions on legal preconditions. And it seems that today we are facing a development that tries to get rid of this, these preconditions and make the political system the dominant and absolute system. So it's in Luhmann's terms, it's a de-differentiation of the international relations.
Hi. I just wanted to pick up on something that the professor, on the professor's question. If I write on this blackboard, 2 plus 2 equals
5.
Exactly. If I write 2 plus 2 equals and space blank, I know how to proceed. The fact that I know what I ought to do in order to answer the formula is based on a practice. The fact that I understand the signs and how to use plus and what equals means, this is due to a practice, right? So my question is, can you really divorce the idea of a practice from the idea of a norm? Would norms, in some sense, be tied to the way we make things, the way we go on? I'm not sure if I'm clear. If I'm not, I can try to elaborate.
Yeah, maybe I try to answer what I understood, and if I don't answer the question, you come again. Is the mathematical formula 2 plus 2 equals a mere convention, a mere social practice? When Archimedes sat in his bathtub and thought about mathematical laws, was that merely reflecting a social practice? Can you really think, and you get it, I'm asking here only, I'm not a mathematician. Even in school, math was not my favorite subject. Could you really say that if a practice changes, the very function of 2, the very function of plus, the very function of equal could change? Because only then, at one time, it would be correct to say 2 and 2 equals 5. Can I think the function of 2 being the unity of 2 entities, and the function of plus being different because a certain practice changes? I don't know. I think in this sense, we have essential truths, maybe. But as I said, I'm really not familiar with different, I know that there are different forms of mathematics, a priori mathematics, conventional mathematics, so different theories of mathematics may come to different answers regarding to your question. When I, maybe to come back on this, when I speak of essential, I'm not applying a medieval or ancient concept of essential, but a constructivist, the transcendental concept of essential, of necessary, and of the nature of law. It is an appropriate construction of the functional unity of certain elements, conceptual elements. I don't know, did I answer your question? Okay, I'm relieved, because if you would further elaborate into mathematics, I would be gone, I would be lost.
Well, I don't want to exploit it more than is reasonable.
Go ahead, this is why I'm here.
I don't know if you have any final question you can raise, and then we'll give freedom to Professor Stefan Kirsten. So, any other questions you would like to raise? As for me, I'll stay the whole morning here. Lots of different things to ask. Any other questions? No.
Maybe a comment.
Yeah.
Ronaldo just applied a negative concept of freedom. I'm free too when I'm finished. But I was advocating a positive concept of freedom. That means a freedom towards something. And I had the freedom to come here based on the invitation by you. And I made extensive use of this positive freedom. Thank you for admitting to make use of my positive freedom here. Now I only have the negative freedom to leave Brazil, which is always full of sorrow. Thank you.